Right now, I want to bring in two guests right now who are going to give us some more insight into this. Former appeals court judge Mary Jane Trapp joins us today, along with our friend Ian Friedman, a defense attorney. Thanks, Ian, for coming back.
Absolutely.
Judge Trapp, good to see you.
Good to see you.
You have been perusing this. Where did it go? This 35-page decision by the judge today, which took him an hour to dissect. What jumps out at you about this?
What jumps out at me is that it was, as you have been saying, very methodical. And trial judges generally don't write 35-page opinions in criminal cases. It's usually a case is tried to a jury. The jury issues a verdict. Juries don't write opinions. But in a case that's tried to the judge, as this case was, it's something that I would have expected from Judge O'Donnell. First of all, he acknowledges the context, the larger context of the decision. And when you're writing an opinion, and I've written over 500 opinions as an appellate court judge, especially in high-profile cases, and in respect to both the defendant and the other parties in the case, the people that died in this case and their families, and the entire community, he acknowledged the pain on both sides, and he acknowledged the larger context and why this is so important. And then what also struck me is that he went through and considered all options, all alternatives, so that you want, as a judge, you want people to have faith in your opinion, that you did thoughtfully consider both sides' arguments.
We were talking about this earlier. As lay people in this room, it was hard for us to understand because he was giving both sides of the argument and going back, so it was hard to tell where he was coming from at this point.
I think when I was listening to it, and listening and reading decisions are two different things, but on page 29, when I was listening to it and then read it, this is where it jumped out at me where he was going to go with the decision, because he outlined what 11 other officers did who were not charged, ending up with one officer who was justified at least 14 shots at Russell and Williams. And when I saw that litany of 11 officers and how many times they shot Russell and Williams, that's when I figured out where he was going with the case.
As a former judge, when you saw him leave the bench there and go down to those exhibits and make his case, how surprised were you?
Actually, I wasn't surprised at all, because I know Judge O'Donnell from both of our prior lives. Judge O'Donnell was one of my opponents in civil cases. We tried civil cases against each other. And as a trial lawyer, you understand the value and the benefit of explaining to people your decisions and your views by using demonstrative evidence. So when he jumped off that bench, it really didn't surprise me at all.
Ian, let me ask you, this is a question from a viewer, and it's an interesting question. If enough, one of the arguments here from the judge is he could not determine beyond a reasonable doubt actually which bullets killed Timothy Russell and Melissa Williams. So this person's question is, if enough officers fire bullets so you can't tell which killed the person, doesn't that mean to get away with murder, just fire more shots from more guns? It's an interesting question. How do you answer that?
It is an interesting question, and those right now who are hurt by it and not looking at it objectively, the judge and I will probably tend to look at this more objectively because we sit in those courts where these human dramas and traumas play out. But I could see how people would look at it, and of course the answer is not shoot more, but sometimes you do face situations like this where it is difficult to say exactly which bullet caused the harm, and this is the result you're going to have. Now, the very next case, you may be able to. Every case is different, and so one of the questions also that was asked is, what does this case mean for other cases? It doesn't. I think Judge O'Donnell's decision was so precise and it was so detailed and fact-specific to this case that we really have to look at it for what it is. It is the decision and the facts and the law in the Michael Brelo case. The next case is the person who emailed you. We don't see facts like this very often. And so, again, I don't want there to be this belief that this always happens. This is... We're sitting here on a Saturday afternoon talking about this at 2 o'clock because it's not an everyday occurrence.